For anybody who doesn't know what's going on, we're live on the main channel where we've got screen in screen. Me streaming the inquiry. And it's so confusing. This might blow the algorithm's artificial brains. So we're live. This is the intro video, but we're going to, I'm going to explain what the heck is going on in 30 seconds. Got to make sure we're live on Rumble. I think we're live on Rumble as well. Okay, I see some comments. Let's just see. Yeah, this is so confusing. Audibly for me. Where's that super chat? Where's that super chat's in the stream and stream? Okay, this is nuts. I'll explain exactly what's going on right now. Viva, what is your memory of the local businesses shutting down? I remember it being some by their choice or forced by local government or police to make it inconvenient for the convoy. I believe they were told to shut down by recollection, and the one that stayed open, the iconic cafe, got harassed but proper by the police. Okay, so now I'm going to stop what's going on because this is just going to get too confusing. I'm going to back myself out of this stream, remove there, and now we're still live with that stream, which I'm going to remove from here. Now, I still hear it, so I got to take my headphones off. Chat, the lighting is not good. I've rearranged the office. Hold on. Okay, I've rearranged the office. Let me get my little mat here for the acoustics. All right, and now I'm going to explain what's going on because it's confusing to me, and I tend to do relatively well at multitasking. This is audibly confusing, visually confusing, technologically confusing. I'm still in my office, Christopher and Josie. What is your background? I'm in my office. I'm just trying to simplify the background, fix some lighting issues, and fix some audio issues. But it was mostly the background, and I wanted to try. So we'll see how it works. This is what's happening. It's going to be very confusing. Someone had the great idea, Viva. We were talking about streaming the Emergencies Act inquiry, but it's going on for 6 weeks. In as much as I love talking. I don't know what you mean, but are you serious about? In as much as I love talking, I can't sit in front of the computer for 8 hours a day for 6 weeks because people have to appreciate this hearing is going to go on until I think November 23rd. It started Monday. When did it start? No, it started last week. So this is going to go on for 6 weeks. It's going to be, boring, but people want to see it. So someone said, Viva, run the stream on your second channel, Viva Clips on YouTube. Run it on a second stream on Rumble with the chat so people can talk, share ideas. Okay. And I'll pop in as often as I can. And this way, I can pop in whenever I want. I don't have to be there all the time, but I can follow the chat as I'm doing. And it's a great idea. Viva, I have to say, you truly look the part of the Florida man beach bum surfer type, from one Floridian man to another. Welcome to my beautiful state. Well, thank you very much. The only irony is that I had the hair back in Canada. It was the freedom fro. Do we all remember this? I said I'm growing the fro until we have freedom. We don't have freedom yet. So that's what's going on. So right now, let me see if I can get this is the current stream, which is very confusing. Okay, good. Now I'm going to StreamYard. Oh, I better take down that super chat. That'll be confusing. So I want to share. This will be confusing for one day and one day only, and then we're going to figure out how to do it. I'm going to share the Rumble link where you can watch. For those who want to watch the inquiry and not the stream of the day, you can go to Rumble to do it. It's right here. And I'll put that in the stream here. Okay. This is the Emergencies Act inquiry on Rumble. It's also on YouTube on my second channel, Viva Clips. The main stream is right now also on Rumble. You have the pinned link there. Is that clear, or is that totally confusing? And now every now and again I can just go like this and bring myself into the stream, and now I'm back in I'm in two streams at the same time right now. No, I'm not, because I haven't shared it. Add to screen. Now I'm back in two streams at the same time. It is called Streamception, people, and it's nuts. But it's good because I'm going to pop in and out, and I'm listening to that inquiry, while I'm walking around the house, driving myself crazy with this. Okay, so now I'm gonna stop share screen. Now we are strictly on the main stream on YouTube. That will be running in the background. Comments, chat, you can all figure it out. You can super chat if you want as well. No pressure whatsoever. I'm going to keep my headphones off because I can't seem to mute the back screen. I can't seem to mute the second stream without actually muting the stream. So that's it. Now I don't know which stream I'm in. Oh, I'm an idiot. Hold on. This is going to be very confusing. I think I pulled the hearing out of the side stream. Okay, there we go. Now I'm going to pull myself out of there. And I'm still live here, and I'm going to remove that. We can see your StreamYards. Okay, now it should be good. In StreamYards, on the second channel, it should be good. This is confusing, but we'll get there. And now I'm back to the main stream. I'm going to stop sharing that screen. Okay, good now, good now. Put a mirror behind you. Oh yeah, that'll. Okay, so today's stream, by the way, and it's a black pill. Oh my God, Viva, these tech issues make me leave. Well, you have to. This is a learning curve for all of us, so you have to bear with me because I haven't done this before. He crossed the streams. We're live here. We are live on Rumble. And all good. Phenomenal. Now, I'm going to start with the video that I wanted to start with, and then we're going to see if this actually works. I wanted to start with something that would make us laugh a little bit. Something that might make you cry. The chickens coming home to roost. AOC getting, not comeuppance, but AOC reaping what she sows. Protest has to be disruptive for it to be effective. AOC out there protesting the Supreme Court justices. But when it comes home to roost, all of a sudden, it's not so funny. Here. Are we hearing this? Look at the arrogant pomposity. She just stuck her tongue out like a disco dance club. Do we hear the audio? We hear the audio, correct? Protest has to be disruptive to be effective. But if it's too disruptive, it becomes criminal and then prosecuted. But only if it's on one side of the political aisle. We've talked about it before. We're going to talk about it today. The January 6th violent riot that has led to 2 years of public inquiry, 2 years of committee inquiry. 2 years of committee inquiry. It has led to people being jailed in pretrial detention for nearly 2 years. It has led to people being jailed for nonviolent crimes, people being denied fundamental rights, allegedly abused in prison. But, you know, the thing that people don't seem to recollect was the plan to disrupt Donald Trump's inauguration in 2017, burning of cars, protesting in the streets, violent riots. Virtually everyone who got arrested in the it was called Disrupt 17 or Disrupt January, whatever it was called, Disrupt January 17. Virtually all of them, if not a significant portion of the people who protested, violently destroyed property, charges dropped. In the summer of love, George Floyd protests, arrested, released, mostly fiery, slightly fiery, but mostly peaceful protest. Yeah, J20. Released. Not only were virtually all of those charges dropped as well, you had politicians raising funds for bail money for the people who were arrested. Raising money to, arguably support criminality. But January 6th, 2 years of inquiry, pretrial detention for many, and now Bannon gets sentenced today for defying a congressional subpoena in the context of that. Hold on. Never super chatted, but still feel miffed. Well, don't do that. Okay, now before we get into the day, Huyip, can you comment on the convoy lawyers' questioning tactics regarding not pinning the whiteness down when they have made false statements? Thoughts? I have to know more specifically what you're talking about. Huyip, but thank you very much for the super chat. All right, standard intros. No legal advice, no medical advice, no election fortification advice. Super chats. YouTube takes 30% of super chats. If you want to support the channel, you want to support me and my endeavors, you can also follow on Rumble. Rumble rants, the equivalent of super chats, they take 20%. You can follow us and support Robert Barnes and me at Locals, vivabarneslaw.locals.com. But every now and again, it happens that I also get a sponsor that is courageous enough to sponsor the channel and a product that I feel good about and that I actually use. I can't seem to find the picture of our EnviroCleanse air filtration system. But we have dogs in the house. We have a kid with asthma, and clean air is an important thing for us. We had one in Montreal. And so when I find a product that I like, and when I find a product that's good, or they come to me and I say, let's see if we can work together, I have to like the product. I have to believe in the product. So EnviroCleanse. It's a cube air filtration purification system. It's got a HEPA filter in it. It's got patented technology in the filter itself that neutralizes bacteria up to a quarter of the size or half the size of the Rona virus thingy thing. It's quiet. It's beautiful. It's perfect. It's also used by the Department of Defense. So if anybody had any doubts, I don't know, maybe some people have more doubts, but if it's good for the Department of Defense, it's good for us. It's in 300,000 schools in the United States, classrooms in the United States. I spent a good half hour on the phone asking about the filtration system, the patented technology. It's amazing. EnviroCleanse, if you go to ekpure.com, Echo Kilo Pure.com, promo code Viva, you'll get 10% off the unit. It's expensive, but it's $699. But sometimes you need to get the good things in order to get the good things and not waste money on the bad stuff. And you'll also get, if you use the promo code ekpure.com, promo code Viva, you'll get an air quality measurement system, which is also phenomenal. That'll let you know what your air quality is like and whether or not the filtration system is doing a good job, which it will. And it's a third-party mechanism, so it's not the product, it's not the company itself confirming the effectiveness of its own product. EnviroCleanse, ekpure.com, promo code Viva, 10% off. They have 0% financing availability, and you'll get the free air unit, which air testing unit device, which is I think $80 or something. Okay, and I'd like to thank my sponsor. Oh, sweet merciful goodness. So it's a Friday, and it feels like a black pill Friday. There's 3 bad newses coming out for the day. It is true, people. You have heard correctly that Brian Peckford and the other plaintiffs who were challenging Justin Trudeau's, in my humble view, unconstitutional, and I'll even say inhumane travel restrictions, it was struck down for mootness. It was dismissed for mootness We'll start with this, and then we'll go through the judgment. The judgment is 3 paragraphs long. Set the context for those of you who don't remember, don't recollect. Justin Trudeau, the man who follows the science, evolves with the science, at one point in time, enacted a policy to keep our children safe, that you could not board a plane or train in Canada unless you were fully vaccinated. You couldn't board a plane or train in Canada unless you were fully vaccinated. And let's just even assume that this was at a time when people were under the false impression that the jibby jab prevented transmission. Let's just assume that that's the case, although we now know, according to a Pfizer executive or a Pfizer representative, that they never even tested for that because they were moving at the speed of science. Let's set all that aside. Let's just assume that at some point when Justin Trudeau in his benevolent dictatorship thought that it was a good idea to impose this restriction on the ability to board a plane or a train in Canada for the unvaccinated. Let's just assume for the sake of argument, he thought that at first. It became abundantly clear when the breakthrough cases became the cases, and the only breakthrough cases might have been people who actually got vaccinated and didn't carry, transmit, or contract the virus. When it became clear very soon, and I think it was clear before, the Rona jibby jab did not prevent contracting, carrying, or transmitting the virus. That's why the moving goalposts went very quickly from 100% effective, a la Albert Bourla tweet from April 1st, 2021, 100% effective. How quickly it went from that to, well, it'll prevent severe symptoms and hospitalizations. It went from get it to protect grandma to forget that we ever said that. And now we got the fact checker saying, no, we never said it would prevent transmission, even though Albert Bourla tweeted out on April 1st, 100% effective at preventing cases in South Africa. Joe Biden said, get the vaccine, you will not get the virus. It stops it. MSNBC fake news propagandist Rachel Maddow describing in meticulous science how it will prevent you from getting the virus. If you get it, you're protected, and you will not give it to granny. So even if you're not at risk from the symptoms, get it to protect granny. Dr. Fauci on June 2nd, 2021, saying the same thing. Oh, the way it prevents you from getting it, so you'll be safe. Forget all that. Forget the moving goalpost. Justin Trudeau, in all of his scientific wonder, imposed that restriction. Unvaccinated Canadians in a country that is I think it's the 3rd biggest country by way of landmass in the world, with a population of the state of California. People couldn't travel. They couldn't visit loved ones. They couldn't be with loved ones for weddings, funerals. They couldn't live a dignified life because of Justin Trudeau. And some of them took it to court for judicial review of the policy. One of whom was the Honorable Brian Peckford, the last living signatory, the last living signatory to the Charter of Rights that the Honorable Brian Peckford believes, and rightfully so in my view, is being desecrated and violated by Supreme Leader Justin Trudeau. So they filed suit. I think it was an application for judicial review. I'll get the proceeding. Basically, calling on the federal court to review and declare unconstitutional the order because it violates charter rights. That was I think it was about a year ago. If it's not a year, it's pretty close. Brian was on my channel. We did a phenomenal interview. It's amazing. Just like by virtue of being old, you've lived through stuff. You have a history. You have a lived history, and with it, a lived knowledge that most people don't have unless they have a functioning brain and have reached that stage of life. So Trudeau says, no travel for the unvaccinated, 12 years old and up, can't get on a plane or train. Peckford challenges it, and it's about a year ago. If it's a little under a year, the trial, the judicial process goes on until today, and it's going to go on forward because they're going to appeal the decision. It goes on for about a year. They have depositions, they have court filings. They sit down and they depose. I think Keith Wilson, who's the attorney on file for Brian Peckford, I think he said they had like something like 4 weeks of depositions, various medical experts. They had weeks on end of depositions in this file. Discovery, getting admissions, getting statements on record that all of these medical professionals, all of these politicians passing the buck. Oh, I never made any decision. That was recommended to me from there. What evidence did you have to support any of the measures you had? Well, I didn't have any. That wasn't my department. Go to this person. This person says, well, I didn't have any. Go to this person. They had their depositions. And you have to appreciate, by the way, this will be relevant, for the absolute, in my view, judicial abuse here. Peckford's paying his own legal fees. Brian Wilson, Keith Wilson is not, he doesn't work for free. He doesn't dedicate a year of his life to work for free, families, houses, bills, etc. Now, he might be working at a reduced rate. He might be working much more than he's billing in a file. That typically happens with responsible lawyers. But Peckford has to pay Wilson. Wilson needs to get paid. It costs money to do this. Lots of money. Now, I don't know what they said. I don't know what they said in terms of cost, but I think it is easily over $100,000 in fees. Yeah. Peckford's got to pay his legal fees. He can crowdfund, etc. So maybe he's not paying for them. But Wilson's not working for free. Wilson's got to get paid. That money's got to come from somewhere. The government, on the other hand, well, that's the beauty of playing poker with other people's money. The government has unlimited resources. This is no skin off their back. It's not like Justin Trudeau's paying for these legal fees out of his pocket. We're paying for it as taxpayers. We're paying for the process through which we are being abused as citizens. So yeah, let's just say it's a cool $100,000 that Peckford has incurred. Maybe it's less. Maybe it's $50,000. It's expensive. Litigation is expensive. Peckford and Wilson are playing with real money. Justin Trudeau is playing with our money. So they go through the process: court filings, depositions, transcriptions. People have to appreciate a day of deposition, other than costing like $2,000 in legal fees at least, other than taking a day of prep for every day of deposition. The stenographers need to get paid. Court costs. You order a transcript of a deposition, it's going to cost you several $100s. So they do this for 9 months, close to a year. And in that time, it becomes not unscientific, it becomes politically unpopular to continue with these measures. Justin Trudeau only recently, I think it's in September or a little earlier, they didn't rescind. They suspend the policy. They suspend the impugned charter violation policies. And they say, don't worry about it. Okay, it's over. I'm done hitting you, so you can't sue me for abuse anymore. They suspend, and they specifically did not rescind, did not revoke, retract, renounce. They suspended the policies. We'll suspend them for now. If it becomes necessary to impose mask mandates, now Dr. Kieran Moore is saying that, if we reserve the right for the future, but it's suspended for now. They actually have the audacity to then say, well, we've suspended the impugned charter violation, therefore it's moot. You have no case in controversy anymore. I've stopped hitting you, so you can't get an injunction anymore to prevent me from hitting you because I'm not hitting you anymore. Now, I know that it's not entirely analogous. Thank you. Suspended June 14, 2022. I know it's not entirely analogous, but I haven't yet found the reason why. The fact that someone physically assaulted you in the past, you won't get. You know what? Let's just take the convoy analogy. The fact that they were honking, and you could have gotten an injunction so long as they were honking, doesn't mean that you can't sue for damages for the honking later on. Unless you're the government. We've abused you. We've violated your charter rights through a policy for however long. Now we suspend that policy. Okay, fine. So now I don't need an injunction to allow me to fly, but I want damages for my charter violations. But no, Trudeau and the government actually came in and said, no case in controversy. It's moot. It is moot. Dismiss the lawsuit. And they had a hearing on September 21st. First of all, you imagine, the trial was scheduled for September 21st, I think, give or take. They present this motion to dismiss for mootness. Then the judge says, okay, well, we're going to put off the trial we're going to put off the hearing on the merits so we can hear the argument for mootness. Imagine the judicial process, the abuse of the judicial process, the arguable abuse of the judicial process. We're ready for trial, suspend the impugned charter violations, and then say, we don't need to go to trial now, and we're going to make a motion. And instead of going to trial, for which everyone has been preparing for a long time, we're instead going to use that date to hear the motion to dismiss on mootness, and we'll put the trial date off a little later. Okay, well, they did that on the 21st, and I interviewed Keith Wilson on the 22nd. How's the audio, by the way? Just let me know if the audio is good. I interviewed Keith Wilson on the 22nd, and I said to Keith afterwards, he went over all the arguments that they raised. And I said, if they dismiss this for mootness, that's going to be a black pill for me. That's going to be the absolute kick in the teeth after they've broken your knees and shoved you to the ground. I was like, they can't do it. The trial for which everyone has been preparing for a year is barely in a month. Whether or not the policy has been suspended, we need a declaration to know how and when you can do something like this, if ever, in the future. So I said, if they dismiss this for mootness, it's going to be a black pill for me, because it's such an obvious question that needs to be answered. Okay, it's no longer in effect. Was it justified when you did it? And set the legal threshold for when such a charter violation can ever be done again in the future. What do you need? Do you need a doctor that says it's absolutely necessary, which they didn't have? Do you need a doctor to say it's more likely than not beneficial, which I don't even think they had? There were emails showing that this measure, this draconian unconstitutional measure, was not based in science. It was based in politics. And the suspension of the measure itself was also not based in science. It was also based in politics. They argued dismissal on mootness, and it came down at 11:30 last night. I'm on Twitter, and I see a tweet. That says it was dismissed for mootness, and I said I messaged Keith, and I said, is this true? And he said yes. Here, we see this. Dismissed for mootness. And by the way, there's an extra. They've kneecapped us. They've shoved us to the ground. They've kicked us in the teeth. Well, here's the kick right up the butthole. Because the hearing was on the 21st. And I did the interview with Wilson on the 22nd. The hearing on the merits was scheduled for October 31st to November 5th. Let me just double check the date. The hearing was scheduled. Where the heck is it here? No. Dude, where's the... Wow, I'm going crazy. It's right here. Okay. The hearing was scheduled for October 31st to November 4th. So just bear this in mind. The hearing was on the 21st to declare moot, to dismiss for mootness. I interviewed Keith Wilson on the 22nd. The trial on the merits, the hearing on the merits was scheduled for October 31st, barely a little over a month later. I said, there's no way they're going to wait any extended period of time to dismiss for mootness, because a 5-day trial with tens of thousands of pages of evidence, you don't prepare for that the night before. You prepare for that the month before. So I said that the longer this goes, the more likely it is that they're not going to dismiss for mootness, because they know damn well everybody's going to prepare for a trial that's coming up. You don't wait till the day before. The only difference is Trudeau and his team, they pay their lawyers with our taxpayer dollars, no skin off their back. They've been preparing probably since January. Peckford and the other plaintiffs are paying their attorneys with real money, their own money or crowdsourced money. So we're paying twice, by the way. I said the longer they wait, the better it's going to look, because they can't wait until the eve of the trial to dismiss, because they know damn well people are going to be preparing for the trial. Responsible attorneys will be. I was wrong. Wrong again. Where did I just get the wrong for the right reasons and right for the wrong reasons? I don't even know what that means. No, I was wrong. Last night, a month after the hearing, they dismiss it for mootness. But let's read this here. Let's read this. Okay, good. This is okay. So we got one plaintiff, Peckford, et cetera, applicants, Attorney General of Canada, respondent, and between Sean Rickard, other applicants, Attorney General of Canada, judgment, reasons to follow. It's only been a month. We don't have reasons, but listen, given that a 5-day judicial review in these matters is scheduled for October 31, and in order to avoid additional preparation time, in order to avoid additional, if you knew you were going to do this, and you probably did from the day after the hearing, it's not like a chess problem that you take it home and you look at the pieces and it just clicks the solution. No, this judge, for all intents and purposes, and by all, fly out there, feather hair. In my mind, there's not a chance the judge went away from this hearing conflicted. It's not like this was a chess problem where you have to go and discover alternatives and say, oh, that was the solution all along. No, it's not like the judge went away on the 21st saying, I'm torn how I'm going to go. No, the judge probably knew exactly where the judge was going to go. And so in that case, waiting a month to issue an unreasoned decision for these reasons makes even less sense. Given that a 5-day judicial review in these matters is scheduled for October 31, 2022, and in order to avoid additional prep time, because they know that they've already incurred a lot of prep time, the court is releasing this judgment, reasons to follow in both official languages, yada, yada, yada. The proceedings leading to the issue of this decision were conducted in both official languages. Okay, yeah, fine. But why would... This is what took a month to draft. The court's reasons should be issued simultaneously. Okay, great. They will be as soon as the translation is completed. All right. They will be as soon as the translation is completed. So is that to say, when was the judgment realized in the mind of the judge? They waited until October 21 or October 20th. That is a fly. The respondent's motion is granted. The applicant's application for judicial review are struck as moot. The parties shall provide written submissions on costs not exceeding 5 days within 10 days of the reasons to follow. Costs. Costs are not legal fees, people. Costs are not legal fees. Costs are court costs. Stenographer, bailiff, transcriptions, audio recording, whatever. It's judicial costs, not judicial fees. So the judge, because of the urgency of the situation, doesn't issue a motivated decision, says reasons to follow given the time constraints, but waits nearly a month. Do I kill the fly? I can't kill the fly. Waits nearly a month to issue this decision. You can call me whatever you want. To me, that feels like the extra kick in the butt after the kick in the teeth, after being shoved to the ground, after having your knees, clubbed. The judge waited a month to issue an unmotivated decision because of time constraints. Why couldn't that have been done a week after the trial? Are you telling me a week after the hearing, the judge wasn't already certain that the judge was going to dismiss for mootness? Bull. Hey, but wait, whatever. What's the big deal? Government pays for their legal fees with our taxpayer dollars. Peckford, who I know has been preparing for this, paying for it through crowdfunding or his own funds. Eat the fly. You will eat the fly and like it. So it's an absolute black pill. The government can abuse you through unconstituted. Now, by the way, they're going to appeal. So who knows? This might not be the end of the story. Damn well better appeal. But this is the black pill of the day. The government enacts what I believe is clearly unconstitutional, unscientific, inhumane policy. You sue. The process takes time, a long time. It costs money, a lot of money. And then the government says, we're suspending it, so no harm, no foul, and no lawsuit. And a judge bought it, at the very least for now. It's preposterous. So there's that. I hope I have not upset people. And then people say, the system works. Moot. It's moot. And if the government does it again in the future, you got to start from scratch. different times, different circumstances. It might be a differently worded policy. Start from scratch. Rinse, recycle, repeat, whatever the expression is. Rinse, repeat. Okay, so that's the black pill out of Canada. Now what we're going to do, I think the link is in the pinned comment, but I'll put it back here. We're going to go to we're going to go move it over to Rumble now. And we're going to do Bannon, which I don't really think there's much news on it. I mean, there's news, but it'll be quick. And then Trump, we're going to go through this court order in which Donald Trump's attorney, the judge basically says, from what I understand, I haven't read the decision. We're going to read it together in real time. I've read the articles, read the reviews. No solicitor-client privilege when there's an alleged crime involved in the correspondence between client and attorney. Hey, criminal attorneys, get ready for you to reap what you sow, much like AOC. Be dancing around whether or not your correspondence is going to be... What do you mean I totally forgot Rumble? No, we're both streams are live on Rumble. I may have forgot. Okay, let's see. Okay, we're going to move over to Rumble right now, everybody. Be kind enough to find the party over there. I'm going to remove from YouTube. There should be super chat. There should be super chat here. Let me just see if we've been demonetized. That might... No, we're still monetized here. There's super chat and Rumble on both streams. So no pressure, no expectation, but if you're so inclined, it's there. Okay, now we are going to end this on YouTube, mosey on over to Rumble, and we'll be smoother the next time. But this inception, Viva live stream inception was confusing, and I think my brain has connected different